My little niece does that. Okay, every time she takes a picture. All right, y'all. What's going on, y'all? Okay, court is in session. Okay, I have an email. Well, I have a few, but I want to go through this one because it's a good one. Why can I not find them all? All right. I'm not going to say the name. Someone wrote and said, hello. My question is, can a landlord or maintenance dude keep showing up at an apartment without any proper notice and enter like the same day with the excuse of occupancy check? This is what a friend of mine is going through because of non-payment of rent due to a lost job. Does the tenant have any rights in the matter against the staff, the landlord, and the maintenance? And if so, what should my friend do? Come on, guys. Let's order in the court. Let me pull you into the court of my public opinion, and let me give you a little advice on what you need to do. Guys, what y'all have to realize is it's the same way. It's the same thought behind it. Just in the criminal, like when I tell you in criminal cases that a bonding company can't get off your bond just for non-payment, okay? People have to follow the law. A bonding company has to file the proper paperwork to get off your bond. A landlord has to file the proper paperwork and get a judgment against you, putting you out of their home. What a landlord likes to try to start to do is retaliate against you, but that is a crime. It is against the law. They are subject to civil penalty if they do that, and you can file a case against your landlord for retaliation. It doesn't matter that you owe them and that you haven't been paying them. If they don't have possession of that premises and a court has not given them possession and then has given them a writ of attachment to put you out, they can't start messing with you, screwing with you, walking in your home. They're underneath the same rules they were underneath because technically you're still underneath a lease. It may be a holdover, it may be a month to month, but they cannot do things to you that they're not supposed to do by law just because you owe them, unless they take you to court, they get possession of the premises from a judge, you are evicted, you refuse to leave, and then they get a writ of attachment and the sheriffs come and tell you have so long you better get out. After that writ of attachment has been issued, then they can start doing whatever they want. Then they can walk in and put you out. But until then, they don't have possession of the premises because you have refused to turn it over. And they've got to go a step farther if you're refusing to turn that premises over. Long story short, what they're doing is wrong. They can't just walk in. They cannot do that. They cannot do an occupancy check. No, they cannot. End of discussion. And when somebody does stuff like that, you're supposed to write certified mail, send it to them, okay, and start keeping track of that. Because when they start receiving certified mail of you stating you entered my apartment on this day, this day, this day, this day, this day, and I believe that you are retaliating against me improperly, then we have a case, okay? There, landlord retaliation is a big deal. And a lot of people don't understand that, but it's a huge deal, okay? The Texas Property Code is very, 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 very clear with respect to retaliation by a landlord, okay? And it's in section 92.331, okay? I'm going to read a little bit of it. Look, a landlord cannot retaliate against a tenant by taking an action described below, okay? Just because the tenant, one, in good faith exercises or attempts to exercise against a landlord a right or remedy granted to the tenant by lease, municipal ordinance, or federal or state statute, a holdover, a person that's in there that didn't pay, okay? Because although you did not pay, you are guaranteed to remain in that home until they legally put you out, okay? A landlord may not retaliate against you, okay, because you give a landlord notice to repair or exercise a remedy, okay? A lot of landlords like to retaliate when you start asking them to fix stuff. They cannot do that, okay? A landlord cannot retaliate against you, a tenant, because you complain to a governmental entity responsible for enforcing building or housing codes, public utilities, or others, okay? If you get a nonprofit agency on their ass, if you tell on them, no AC, they cannot retaliate against you for that, okay? For these, if you're doing one of these two things, and if the tenant has moved forward, okay, with trying to fight the apartment complex for housing codes or violations, or if the tenant believes in good faith that there's a true issue, a true underlying issue, okay? Or if they establish or they're attempting to establish or participate in a tenant organization. These are all reasons and things that people use to try to retaliate against you, okay? And it's just how it is. So landlords cannot, within 6 months after the date of all of those actions that I just listed, file an eviction proceeding, except for the grounds stated in 92.332, which is non-payment or other things, like if there are crimes going on. 2, deprive the tenant of use of the premises, except for reasons authorized by law. And that's what they're doing. They're depriving the tenant of use of the premises by constantly coming in. Because, I mean, you don't want to leave your stuff in there. They're coming in on you. You could be naked, okay? Decreasing services to the tenant, all right? Cutting shit off. They can't do that. Increasing the tenant's rent or terminating the tenant's lease, okay? Or engaging in bad faith in the course of conduct, busting in there all the time on an occupancy check, engaging in bad faith in the course of conduct that materially interferes with the tenant's rights under the tenant's lease. And that's what they're doing. So from what you're telling me, it seems as if, this person is getting retaliated against. I assume, like you said, they owe money, okay? And so what the landlord has begun doing is began eviction proceedings, and they have not concluded them, or else you wouldn't be writing me, okay? So no, they cannot do this. That is retaliation. Y'all need to get an attorney, but I don't assume that your friend can afford one. So they're going to need to probably go to Texas Self-Help or TexasLawHelp.org, TexasSelfHelp.org, TexasLawHelp.org, and see what they can do. But it talks about retaliation. You can also file retaliation claims in the Justice of the Peace. For a while, Justice of the Peace could not issue injunctions. I believe they have the right to do so now with respect to landlord-tenant issues. So you can bring that there, or you can bring it in the county court. Okay? But no, they're not right. Okay? And your friend needs to start documenting what's going on, and y'all need to serve these, well, not serve them, but give these agencies or the landlord and the management company notice via first class and, which is regular mail, and certified mail stating, like, these are the things that you are doing, okay, against the law, and I'm putting you on notice that I understand you're doing these things, and you better stop before I bring my retaliation claim against you. If you want me out, you have to legally put me out. And until then, you will not bother me like this in the way that you're doing. Okay? So that's what's going on. Okay? Initials are LS, and I did email you to let you know to watch this show. So this is the one, sir, and this is the response. If you have any other questions that you're following up, based on what I said, if, your friend has questions, you guys reach back out, and we'll do a follow-up. Thank you. Court is now standing in recess. Until next time. No, I'm just joking, y'all. Bye. Happy Monday, y'all.